Good afternoon, everyone, and welcome to the Horace Coil Chairholder Lecture, delivered today by our own Rick Marcus. Horace Coil graduated from UC Hastings in 1957, and at the age of 21, became one of the youngest students ever to pass the California bar. He was a prominent attorney in Newport Beach, specializing in personal injury law. He was dedicated to public service, serving as the head of the State Disciplinary Board for lawyers, volunteering for the American Heart Association and the American Trauma Society, and participating in several community organizations. He embodied the spirit of service to the profession and to the community that is really at the heart of our mission here at UC Hastings. And I want to give a special thanks to the Coil family for the support of that mission. Horace's brothers, John and Henry, established the Horace O. Coil Professorship in their brother's memory. And John is actually with us here today, so I hope that you'll join me in welcoming him and thanking him and his family for their generosity. No one could be a more fitting holder of the Coil Chair in Litigation than Rick Marcus. Rick joined the UC Hastings faculty in 1988 after teaching at Illinois and Michigan, and became a distinguished professor here in 1997. He was awarded the Horace O. Coil Chair in Litigation in 1999. Rick is a leading expert in all things litigation. The author of leading casebooks on complex litigation and civil procedure, the author of several volumes of the Federal Practice and Procedure Treatise, misleadingly attributed to Wright and Miller, the associate reporter to the Advisory Committee on Civil Rules of the Judicial Conference of the U.S. and drafter of amendments to the Federal Rules of Civil Procedure on class action and discovery rules, Vice President of the International Association on Procedural Law, and advisors to several international bodies involved in drafting procedural rules. Rick is the author of more law reviews than I honestly had the fortitude to count. But what I did learn in perusing his body of work is that Rick also has quite the knack for drafting a catchy title. Benign Neglect Reconsidered, Scourge or Savior, Slouching Toward Discretion, Only Yesterday, Confessions of a Federal Bureaucrat, Not Dead Yet. For a moment, I thought I had mistakenly Googled the lineup of the new Netflix original series rather than a list of civil procedure articles, but I digress. Rick's lecture today draws on his vast well of expertise and experience in the field to reflect on the ever-evolving relationship between technology and litigation in his talk today, Brave New Worlds for Litigators. And with that, I turn it over to Professor Marcus.
Thank you very much, Jody. I hope you can hear me. I see the little halo around my face there, which should mean my words are going out to you. I come to you today dressed this way for the first time since March 16th, partly as a sign of respect, particularly to John Coil, but also partly just plain it's cold here. And so I'm wearing this, but I can see Dorit seems to be having a similar attitude. I gave a Coil lecture in 1999, which one of Horace Coil's brothers attended. I don't know if it was John, but I think I'm going to try to adhere to something that was advice I got from Mary Kay Kane before that lecture when I asked her whether the topic seemed suitable. And she said, yes, it seems suitable, but she had one major piece of advice for me, which was, above all, be brief. So I'm going to try to do that and run through thoughts that are sort of dispersed or wandering grab bag of thoughts about technology and litigation, civil litigation. Criminal cases present different issues. And for any of you who have ever looked at all the things posted outside my office back when we could go to the office and look at things posted outside offices, you will know that I am probably the institution's leading technophobe. And so I begin with the comments of what is probably, in the Anglo-American world at least, the biggest enthusiast about technology, particularly in litigation, Richard Susskind, who's an English law professor and who said 20 years ago that technology, IT in particular, would fundamentally, irreversibly, and comprehensively change legal practice. And he said that by 2015, the main way in which legal service would be delivered across the world would be through online legal service. So I'm not here to tell you that's happened, but I am here to tell you that a whole lot's changed, and even a technophobe like me can't deny that that's been significant. So my conclusion is going to be, even somebody like me doesn't claim to be able to stop, I used to say, the glacier of change. You know, you're trying to lean against a glacier and getting it to stop is not going to work. But now I guess climate change is reversing that progress of glaciers. I'm going to try to march quickly through basically 6 things to get around to that conclusion again. 1, the good old days. Back when us technophobes were content. 2, the impact of technology in the 20th century on civil litigation practice. Mainly now we're interested in the 21st century. 3, the impact of technology on a different profession, doctors. That's what Ruhl Schiller was asking about, which is the oldest profession. 4, moving to the present century. E-discovery, big deal that some of you may be familiar with. 5, the ongoing potential of artificial intelligence to affect a whole lot of things, including civil litigation. And finally, here we are participating by Zoom, COVID. And if I remember to mention legislation that's now on Governor Newsom's desk that I just found out about this morning. Okay, so the good old days. Some of you may know that the great novelist John Dos Passos' father was a famous lawyer. And his father wrote a book 100+ years ago saying legal practice in America reached its zenith just before the Civil War, back at the time of Bartleby the Scrivener, which was a Herman Melville novelette set in 1850 or so, and the narrator is a lawyer, and Bartleby the Scrivener is one of his employees. That kind of thing continued to exist in the early 20th century, and for that I use as an illustration a description of the early practice of Justice Robert Jackson, who in his early cases had small stakes trials, which he, according to Noah Feldman of Harvard Law School, which became entertainment features for the communities in which they occurred before justices of the peace. Instead of being in a regular courtroom, they would be in a number of places. One of them, he said, was in a barn. And that is the way things perhaps were. That stopped happening not too far into the 20th century, or gradually phased out. And on that one, I invoked Frederick Lewis Allen, who wrote a book called Only Yesterday, a title that Jody mentioned, in 1930 about changes from the turn of the century until then, and then another one in 1950 called The Big Change, which was about a sociologist's view of America, but it's about technology, cars, radio, telephone, changes in American society due to that. For proceduralists, the big deal was the Federal Rules of Civil Procedure, adopted in 1938, with broad discovery provisions, unprecedented, unparalleled, and they operated in a very different world. And I've just run through a couple, 3, 4 things that were different then to now. I remember when my father, who was a writer, would compose things he was writing was on one of those big black Underwood manual typewriters, which almost you had to have a hammer to hit the key to get it to cause a mark. How do you prepare 20 sets of interrogatories for 20 defendants in a case using that? Well, carbon paper maybe, mimeograph maybe, but in 1938, having litigation on the scale we have now wasn't possible because of things that have happened in technology since then. 2, the telephone. It may have revolutionized legal practice, but you couldn't even direct dial a long-distance call. I think I remember area codes coming in when I was a little kid, long after that. 3, well, maybe we have to go somewhere. Commercial jet travel didn't exist. In 1933, United had service between the West Coast and the East Coast, or the East Coast and the West Coast, 20 hours. And in 1936, the DC-3 was introduced, and it revolutionized travel because it could go nonstop from New York to Chicago. So it was really different to be a litigator then. But that changed. The photocopier changed it, starting in the 60s. It was said, anything important, there's at least 10 copies of it. And if it says confidential, why, there's at least 50 copies of it. Think how much more that meant you could discover. Meanwhile, right after World War II, late 40s, early 50s, protracted litigation became the main concern of, or a big concern of the federal courts. And in the early 60s, the outburst of the electrical equipment cases meant that some kind of nationwide telephone and jet travel enabled judicial coordination was essential to avoid submerging the federal courts. That led in 1968 to the adoption of the Multi-District Litigation Act by Congress, which has become a really big deal, and I'll return to that in a minute. But substantive law was evolving in parallel track, particularly tort doctrines that led to what came to be called mass tort litigation, which began in the 60s actually, but reached public prominence when Johns Manville filed its bankruptcy petition in 1982, because it was supposedly a financially healthy company, but it was facing huge exposure due to personal injury tort litigation from exposure to asbestos. So that was how things changed. And now let me say a few words about doctors. That is, Rule mentioned, C. Wright Mills said in 1951 that the 2 oldest professions in the U.S. are lawyers and doctors. So let's look over at the doctor's side of things. Did technology matter there? In 2007, a historian of technology said that medicine would have been seen 100 years before that, 1907, as to have been largely outside the realm of technology. I don't know about you, but I can tell you my doctor doesn't really much care about seeing me to diagnose my condition. My doctor wants to know, what does the lab say? What does the CAT scan say? What does the X-ray say? Diagnostic activity by doctors now is worlds away from what it was at the beginning of the 20th century because of technology. None of those methods existed then. And so if you think in lawyers' terms, a medical malpractice claim, which would you rather have if you're the plaintiff's lawyer? A doctor who diagnosed and prescribed for the plaintiff based on a face-to-face meeting with the plaintiff and nothing else? Or a doctor who never met the plaintiff face-to-face but relied upon the kind of reports that technology can provide? I would think the former case is an easier medical malpractice case to win than the other. And that's been fortified by the practice of what's called telemedicine. Really not face-to-face. 2007, the San Francisco Chronicle reported that UCSF had begun treating patients, doctors there had begun treating patients that they'd never met face-to-face, adopting techniques that had developed originally at the Cleveland Clinic. The Economist reported not long thereafter that the mobile phone may join the stethoscope and the thermometer as indispensable pieces of medical kit. And on August 26th, which I think is less than a week ago, the Wall Street Journal reported on a couple of companies that offer telemedicine services and had 40,000 online visits a day in April of this year, compared with less than 3,000 in April of last year. So that's where medicine seems to be going, enabled by technology. And it's not just diagnosis. It can be what you used to think of as hands-on treatment. The example that I'm aware of has to do with something some of us might think about, which is prostate surgery. And something I encountered said that robots are almost always used for prostate surgery. They're more precise with a scalpel or laser than a person could ever be. And that improves the prognosis and speeds convalescence. So for the doctor of 2020, things are hugely different from the way they were in 1900 because of technology. So, are lawyers immune? Well, we try to stop change. But my introduction to our susceptibility came in the ARC in January of 1997 when we rolled out for the advisory committee some discovery ideas. And the lawyers in the room said, they were very experienced, thoughtful folks. They said, okay, well, those are all right, but the big problem we have is email. And you should do something about that because it's keeping us up all night. Technology has intruded. That became a decade's worth of effort. Eventually, in 2006, we had what's known as the e-discovery amendments to the federal rules, but these people who said do something didn't know what to do. And meanwhile, technology, I would say, branched out. And by way of illustrating this, in January 1997, I asked the question, which some of you heard me ask before, what was Mark Zuckerberg doing in January of 1997? Now, I think I can't answer that, but I can look it up and tell you he was 12 years old. We couldn't foresee social media. We couldn't foresee Facebook. That's where technology now is the most prominent feature of e-discovery. Oh, yeah, email a little bit, but texting has replaced that. So dealing with these things is what lawyers who engage in civil litigation, and maybe investigations as well, do. And there's so much more data available that, well, I quote at some point a 2017 comment by a Wyoming federal judge who said, quote, more data has been created in the last 2 years than in the entire previous history of the human race. And the amount of data is predicted to grow tenfold by this year, 2020. Just as an aside, because I used to hear these things a lot. How do you decide how to measure data? more data than in the entire previous experience of human history. How much data is involved in the smell of a rose, in first love? I mean, these are techies' view of what counts and what doesn't count, but in terms of what counts in litigation is how do you get your arms around that much digital data? Maybe technology can help. And technology has, with IT, called predictive coding or technology-assisted review, it has supplanted the old-fashioned idea in large measure that legally trained people go and look at all the pieces of paper and they decide which ones have to be turned over to the other side. So that's the current situation. And then we have the Internet of Things, which probably exist in your house. That supposedly, those are various implants in your refrigerator and so on that communicate with the internet, and you may order online from Amazon milk when you need milk, that kind of thing. All of those record data that might be involved in a lawsuit. And they were anticipated by this year, 5 years ago, anticipated to increase to the number worldwide of 75 billion, 10 per person. Legal Tech News in 2018 published an article entitled, "Thanks to the IoT, Internet of Things, this isn't 2006's e-discovery anymore." That's when our e-discovery amendments came on. So rules can deal with these things, but mainly it's a challenge for lawyers. And on that one, I will indulge in quoting to you something that was in a Chicago federal judge's reported opinion apropos some discovery issue. And what he said was, quote, "The court pauses for a moment here to calm down litigators less familiar with ESI, electronically stored information. You know who you are. In life, there are many things to be scared of, including, but not limited to, spiders, sharks, and clowns. Definitely clowns." I'm just quoting. ESI is not something to be scared of. The same is true for all the terms and jargon related to ESI. Discovery of ESI is still discovery, governed by the same federal rules. So get used to it. So we've been doing that, but it's a big challenge. So that's technology now and maybe a little bit in the future, but I'm now turning to my basically next to last topic and trying to stick to schedule here. What about artificial intelligence, AI? It's almost impossible, or it seems to me in the last year or so, 2 years I've been paying attention to this for a conference that was supposed to happen in Brazil 2 weeks ago, but had to be called off. It seemed almost impossible to turn around without reading in a newspaper something about artificial intelligence. What exactly is that? That's debated. It's traced in the leading textbook that I'm aware of on the subject to a series of lectures given by Alan Turing, who, by the way, I think is going to be the face on the new 50-pound note. Alan Turing in 1947. The goal now of AI folks is what's called AGI, Artificial General Intelligence. When can we develop an algorithm that emulates, equals, surpasses the human brain, even ours? That's a topic of international interest. This Brazil conference that couldn't happen was 4 or 5 days to discuss the impact of AI on civil litigation. But let me just suggest some things that may be coming. One, impact on substantive claims. Privacy and data breach is a really big deal, where it wasn't anything like that 10 years ago, 20 years ago, so far as I know. Equifax, for example, settled one class action for data breach for $380 million. Two, discrimination. AI can expedite your hiring, scrutiny, screening of applicants, particularly now when there's so many people applying for jobs because of unemployment having risen so much. Well, how does AI know what to look for? It learns from humans. So AI, we are told, will reflect pre-existing bias in the culture. But some lawyers say, well, actually on the plaintiff side, that's better because it's easier to prove that the formula, the algorithm, discriminates than it is to show that human decision makers do. So employment discrimination may look very different. Third, more speculative, algorithms as parties. The driverless car. If it gets in an accident, who do you sue? Our respondeat superior notions would say, oh, the owner, the operator, what have you. But at least Professor Vladeck of Georgetown has begun speculating, well, maybe at some point that really doesn't apply. Some of you may remember a movie called 2001: A Space Odyssey, in which a computer, I think called HAL, takes it upon itself to do what it thinks should be done, which, as I recall, was exterminate all the humans. When are these algorithms suddenly parties? The EU Committee on Legal Affairs has recommended creating a specific legal status for robots. And a variant of that Ron Feldman has written about is, well, if algorithms really are the forces behind developing patents, maybe they can be patent owners. She says, no, not under our current patent law. And finally, AI and legal practice. The notion is that the notion of David Susskind 20 years ago was, well, algorithms will be things that clients can interact with directly and get legal advice. How does the attorney-client privilege apply to that? Challenging question, perhaps. But is this a good thing for the legal profession? Some people say, oh, yes, it'll take the boring tasks off the lawyer's back and the lawyer can be devoted to other tasks. On the other hand, an article in the Wall Street Journal 2 weeks ago reported on a San Francisco firm called OpenAI, which has developed a program that writes, composes prose, and says for a range of knowledge workers, news reporters, lawyers, coders, and others, this could take the task of composing things and do it for you. Though, as it goes on to point out, well, maybe thinking through what you should put on the blank screen is actually at the heart of being a lawyer. So, prospects for legal practice, uncertain, maybe unsettling. And then finally, quickly, the robot judge. Why, if the programs can write briefs, evaluate the likelihood of success, why can't they decide things too? I just last night encountered an article from somebody in I think the Pittsburgh Technology Journal saying that in Estonia they have algorithms that are actually deciding cases. 20 years ago, the Yale Law Journal carried an article by a computer science professor predicting that it would be possible to model legal reasoning. And judges are already using algorithms to do things like make dangerousness determinations in deciding whether to release people before trial. Those have been severely attacked as being discriminatory, like employment AI, but it's still in the offing. And then finally, COVID, and I'll wrap up. We have embarked unknowingly and not on purpose in the last 5 months with an experiment of how do you go about handling a lot of things, including litigation, when you can't be in the same room together. That's the hallmark of Justice Jackson's trial in the barn and American litigation with juries watching witnesses face to face and deciding who to believe. Well, we can't do that anymore, or at least we can't do that right now. And when it starts to be possible to do that in the federal courts, at least the Speedy Trial Act means that the criminal cases go first and the civil cases come later. So, as Scott Dodson said in an article, I think, planned for judicature, co-authored with Lee Rosenthal, the Chief Judge of the Southern District of Texas, and a Houston lawyer who suspiciously seems to have the same last name as Scott, quote, "The pandemic has pushed lawyers and judges towards remote technology on a scale and at a speed never before seen." So also legal educators. Congress recognized that in the CARES Act back on about page 680 and had some specific provisions about criminal cases and invited the civil rulemakers to decide whether we need an emergency rule. And that's taken a lot of energy since the beginning of April, and we have another conference call scheduled on 9/11 to try to wrap up the most recent portion of that discussion. So I offer you, and then I will conclude, I offer you 3 places where we might see something later, not an emergency. Instead, it's learned behavior. Well, maybe that there's going to be a new normal. After the courtrooms open up, still the experience is going to affect the way litigators work. 1, remote depositions. That's the only way you can take a deposition now. The olden days, you got a whole bunch of people in a conference room, sit them down, they spend all day talking to each other. That can't be done now. So Zoom offers a variety of ways to do that kind of thing remotely. Here is the bill, I think it's called Senate Bill 1146, which among other things proposes to amend section 2025 of the Code of Civil Procedure to authorize remote depositions in California state courts. It's on the governor's desk now. On the federal side, we have a Rule 30b-4, which says the court can order remote depositions, or the parties can agree to it. But now with all this experience, maybe we should just say a party can insist on it. I think that might be what the California provision says. So if you're a client, are you going to really want to pay to fly a lawyer from San Francisco to New York to take a half-day deposition of somebody in New York who's a sort of incidental witness that you could depose by Zoom and save a whole lot of money and not lose anything? We may very well see this come in as a practical matter. 2, how do you persuade your witnesses to come to trial and testify when that's again possible? They may be reluctant. How about allowing them to testify remotely? We have a rule about that, Rule 43A, that says in exceptional circumstances with sufficient protections, the judge can order that. Maybe that should be relaxed. And then finally, there's a question of open court. Rule 77B says all trials must occur in open court and ordinarily in a, quote, regular courtroom, unquote. That's exactly where the trials Justice Jackson was having in the early 20th century didn't happen, in regular courtrooms. Maybe we should relax that. It also says all other hearings can be in chambers, but the judge can't preside from outside the district. Well, how about a judge from New York who has taken refuge in Connecticut during the pandemic and is handling business via Zoom from there? Does that violate Rule 77B? Because the judge is outside the district. Where's the court? So there's a lot of uncertainty here. But one thing that I offer to you as a certainty, and I'm going to wind up at this point, one thing to offer to you as a certainty that this has not stopped and this will not stop. We cannot prevent technology from affecting what we do. So for litigators, I'm going to invoke something that a math professor and folk song singer named Tom Lehrer made popular 50 plus years ago. He wrote a little ditty based on what he said was the Boy Scouts marching song, and its theme is be prepared. Thank you.
Thank you, Rick. Really appreciate the talk, and I want to invite comments or questions by any of our participants. I'm going to look for hands. I'll also try and keep track of anything in the chat box. I see Rule for now. Rule, would you like to kick us off?
Sure. I have a lot of questions about the Estonian robot judges, but I will hold off on those until.
I'll send you a site.
Yeah. My question is about discovery, and I understand the very sanguine magistrate judge, but I guess I'd like to push back a little bit. Presumably, when we create different limitations on discovery and limitations on evidence, we're recognizing that we're giving up some information. For example, the information that a lawyer might say to his client, because we believe there's some other value to protecting that sort of communication. And while I was reading your paper, I found myself wondering whether there's might be something similar with respect to particular items of technology. I'm not wild about the idea that sort of my movement around, for example, might be discoverable because it is tracked because I happen to have my phone with me. And I recognize that that might be useful. And indeed, I recognize that all the information that my phone collects might be exceptionally useful in litigation. But I found myself wondering whether there might not be another value where you might want to create forms of privilege that are not forms of privilege because of the occupation that the conversants or the marital status of the conversants, but because particular pieces of technology collect so much data that they're, of course, incredibly useful for litigation, but they may really cripple for example, our belief in rights in privacy. So I'm wondering whether you could envision forms of privilege that are technology-based privilege as opposed to, professionally or marital status or one of those other forms of privilege.
Excellent question, which prompts a number of reactions that are not about privileges. Privileges, by and large, taking the Fifth Amendment, if you want to call that a privilege out, they're communicational and they insulate certain relationships, and that at least the conventional American ones are quite limited. For example, there's no parent-child privilege. There is a spousal privilege, but not a brother-to-sister privilege. So what you hit upon has at least two aspects that I can speak to more directly. Number one, the 2015 amendment to Rule 26b1 concerning the scope of discovery said that discovery must be, quote, proportional, unquote. And the question whether one of the things to be taken into account is intrusiveness, it has gained currency, including with one of our alumni who's now a magistrate judge in the Northern District of California, named Cousins. And the problem is, frankly, number one, that I will guess I am the only person here who does not have a smartphone. So I'm the only one not being I'm technophobe, I'm serious about. I have nothing to do with social media. And so probably you have all sorts of stuff on your phone besides a GPS, which is material that somebody might want to get a hold of to embarrass you or what have you. So discovery of social media in particular, particularly of individual plaintiffs or individual, say, employment discrimination plaintiffs, personal injury plaintiffs, is a really big issue. And to take your GPS example, particularly in wage and hour cases, that's something that defendants really often try to get. I could find the citation, but the chair of the advisory committee, John Bates of the District of Columbia, recently refused to require disclosure of the GPS information on privacy grounds where it didn't seem important enough to the case. The reality is that people who have discovery tools, and this is defendants as well as plaintiffs, people who have discovery tools may use them in ways that discomfort the other side. And there is Scott's co-author, Lee Rosenthal, I think, is still working on a piece for judicature about whether proportionality includes some notion of privacy. There are certainly provisions for protective orders to cover privacy. The intrusiveness, I think you are right, will be a growing concern, but addressed on a case-by-case basis. Is there a good reason here, as with the GPS case involving Judge Bates that I mentioned? So I think that's responsive.
Great, thanks. So next we have Scott Dodson.
Hi, Rick. Two quick questions, one legal and one practical. First, how might the prevalence of video conferencing technology affect what is proportional under the discovery rules? You mentioned that earlier with respect to privilege, but and then second, pre-pandemic video conferencing was kind of a blunt
Scott, you're freezing up a little bit.
That might be my connection. I hope. Let me just repeat what I just said. So I think post-pandemic video conferencing will be more customizable for the particular industry. So either inherent in the technology producer or through the use of like third-party add-ons and the like. So I guess I'd be interested to hear what kinds of technology enhancements might we want to see for the litigation community to really make video conferencing the new normal for litigation?
Okay, well, I think that question number one is how does this play with proportionality, which I mentioned has since December 1, 2015 been in right up front. It's always, since 1983, it's been in Rule 26, but now it's right up front. And then the other question is, where do we think video conference or Zoom technology will go that will be responsive to to civil litigation needs? First, on proportionality. Definitely, it's a factor, and an illustration I'll use from the 2006 amendments is Rule 26B2B, not known. That said, there is no requirement for a responding party to search electronic sources that are not reasonably accessible due to cost or burden. This was thought to be technology neutral, and actually search techniques have changed hugely since 2006. It would, I say for myself, it would have astonished me then to learn that now it is said that there are ways to search voicemail. See if Mr. Smith was mentioned in any of the voicemail at this company over the last year. The search capacity of technology means that the, at least, burden in some ways and cost of finding things in a huge digital data dump have gone down. So I think that's part of what you're talking about. It can well be that technology will make possible things that were not possible before. On the other hand, in the Mueller report, one of the things I understand he refers to was the habit of some of the people who were the subject of investigation to use automatically erasing email servers. And so maybe technology can expunge things also. So yes, it could have an effect, not sure what effect. Then customizing Zoom or whatever you have. There's lots of things, at least in terms of depositions, and also probably in terms of witness testimony from a remote location that might resemble, it occurs to me, methods of proctoring online bar exams or law school exams. How do you keep the witness from being coached by somebody else in the room off screen? That kind of thing. Finding ways to show the exhibits to the witness without having to telegraph long in advance what they're going to be is one challenge. And I think people are working on ways to solve that. So I suspect the adaptation will be along those lines, but that's just a suspicion.
Great, thank you. Radhika?
Hi, can you hear me?
Yes.
Okay, so Rick, this is such an incredibly timely and thought-provoking paper, and some of these developments are very disturbing. I like Rule's suggestion of tech privilege, but I am in particular concerned about the possibility of the use of some of these techniques as a weaponization, basically the weaponization of lawsuits and litigation as a tool of harassment. I don't know how many of you are aware, but our own colleague, Veena Dubal, is being subjected to such harassment by people opposed to AB5 who are seeking discovery of her email. I read about this in an article. So what about the weaponization of a discovery in order to gain access to email, to social media, and that question?
Huge concern. Part of why I begin discussion with first-year students by asking them, saying to them, which I've sort of said to you already, all the people here who have never in their lives sent a text message, used a smartphone, participated in social media, raise your hands. And there's never any other hand in there. People, both in terms of just headache burden, but also in terms of fairly extreme confidentiality, evidently put lots of things out there, or at least in there. I think that what you're talking about is a 21st century version of something that's been around for a long time. And it used to be described by corporate defendants as one-way discovery. Oh, the plaintiff lawyer is, the plaintiff, individual plaintiff has nothing. And meanwhile, the plaintiff's lawyer can send this huge discovery request to us, which is sort of a little bit relevant, and maybe is seeking the crown jewels, like there's a case involving the formula for Coca-Cola. But basically, it's using discovery as a club to get us to put up money. So you could use discovery as a club for other things too. Well, the intervening protection is a judge, and in the U.S. at least, the subpoena power, not just for Cyrus Vance, but the subpoena power exists for every lawyer. Now in the federal courts nationwide, you can sign a subpoena if you're a lawyer and get it served on somebody wherever the somebody is, and it commands that somebody to do what you're asking to be done. I don't know of a way to protect across the board against what you might call collateral purposes. Call them whatever you are. With like collateral purposes, we're not really trying to get evidence for our case. We're doing this because we want to scare this person off, or we want to sell what we get, because the formula for Coca-Cola will bring a fair amount if we can find the right buyer. And it's been an abiding question that's just become more severe.
Thank you.
Thanks. So next I have David Levine.
Okay, thank you, neighbor, for terrific talk. The area I wanted to raise was, as you were reviewing the 100 years, is how legal research has changed. You know, way back, I learned to shepherdize using the actual shepherds. Centennial Digest, the Reader's Guide to Periodical Literature, and all the rest of it. Surely legal research has changed and the expectations of courts of what lawyers ought to be able to find, et cetera. So I wonder if you could address that a bit. Has the cost gone up? Has the cost gone down? Are we seeing more esoteric sources being presented to courts? Say, bring the Court of Appeal of Estonia to the attention of the Superior Court in San Luis Obispo County or something like that. So I just offer you that topic, Rick.
So we get the Estonian robot judge. Okay. Well, I'm not aware of that. I'm almost certain. First off, I don't know. I'm not aware of people that I've read really addressing that. I think it's sort of implicit that you can get a lot more stuff a lot more rapidly. Like I got this copy of SB 1146 this morning, 20 minutes after I became aware that it existed. There's a whole lot of stuff you can get a whole lot easier. And you can get things that would have been basically inaccessible before. I was trying to find something in a Ninth Circuit case that I thought cited something I wrote, and I failed to find it, but I decided to go to that article on Westlaw and see where has it been cited. And there's a whole list of things, cited in brief in this case, brief in that case, that kind of thing. There was no way to find that kind of stuff before. I'm almost sure people use it. Whether the cost is going up or not, my offhand guess is that the number of hours spent doing it has not gone up, but the hourly cost, if you've got a lawyer doing it, it seems to my perspective, when I started practicing law in 1976, my billing rate was $60 an hour. I doubt that honors graduates of Hastings now at downtown law firms are billing out at that amount. So I bet the dollar cost has gone up, even if the hours invested have gone down, and maybe the hours haven't gone down because there's so many other things to get a hold of. One final comment on Estonia. At a point in time, the then Republican head of the House Judiciary Committee came to the Judicial Conference and almost screamed at the members of the conference about how totally unacceptable it was for them to cite any non-U.S. authority in interpreting the U.S. Constitution. So that's a delicate subject on other grounds, but I don't know more than speculation about what you asked about.
All right, next we have Abe Cable.
Well, Rick, this is a fascinating topic. I think maybe one way that's interesting to think about it is to engage in a radical thought experiment where 20 years from now, we're not all replaced by robots, and nor are judges. And to just try to think through, what are the constraints? Why didn't it happen? I mean, so is it a matter of technology, cost, computer, AI ethics, the fact that lawyers are self-regulating? What do you think stops the full-fledged vision of this?
Well, let me go to the last thing you said first. Lawyers are self-regulating. And certainly the protect our turf impulses of lawyers have something to do with, you might call, access to the profession. Anybody here ever heard of an outfit called Nolo Press? Okay. That was founded by a guy I went to law school with named, I think maybe he was a year or so before I entered, but Ralph Warner came to be called Jake Warner. And now I assume it's online. There used to be books. He was, that Nolo Press was the subject of an unauthorized practice of law proceeding in Texas at a point in time. Nowadays, I think, Abe, it's correct that some places, Minnesota maybe, are retreating from the notion that non-lawyers can have an ownership interest in a law firm. So I think that's in flux without regard particularly to technology. The thought experiment prompts me to offer the doctor analogy. Doctors now still have lots to do. They just have different sources of information to do it with. And it could well be that lawyers 20 years from now are actually going to be able to use their human expertise in ways that is enabled and not defeated by technology sources of information. At 20 years from now, I do not expect to be discussing these issues in quite the same detail as today.
Great. I think that we are going to wrap up there. We're at the end of our time here. I just want to thank Rick again for this provocative talk. I want to thank John and the Coil family again, and I want to thank all of you for joining us here today.